general rule in all jurisdictions is you'll be held, if you're a mere child, to use the kind of care that a child of like age, intelligence, and experience would have used in this situation. So the standard for children is, did you use the care that other kids, similar other kids of similar age, similar intelligence, and similar experience? If they would have been as equally as careless as you, then you've not breached your duty. If kids your age, your intelligence, and experience would have used more care than you used, then you did breach your duty. So the standard is a child of similar age, intelligence, and experience. That's easy enough to apply. It's hard to argue. It's a difficult standard for plaintiff to meet because it's a subjective standard in a way. If the kid is mentally retarded with no experience with farm animals and they're 7 years old, it's going to be hard to prove they didn't use the care that a mentally retarded and inexperienced child would have used. So it's a difficult standard for a plaintiff to succeed with. So defendants always want to use a child standard in representing a defendant child. The plaintiff, having a difficult time with that, would like to argue, in this case, the child is not entitled to the child care standard. They can do that if they meet the exception. There's only one exception in all jurisdictions. The problem is it's a different exception in some jurisdictions than others. So it's a sum-sum situation. In some jurisdictions, the exception is if the kid is engaged in an inherently dangerous activity, we're going to hold them to an adult standard. We will not apply the child standard to a child who's engaged in inherently dangerous activity. At the extremes, it's easy to decide this. You know, if they're flying a 747 and they're 7 years old, and they engage in that activity, they're going to be held to a reasonable person standard. Once the child starts getting in inherently dangerous activities, they're going to pay the same as any adult would pay. Other jurisdictions say, no, we're not going to decide it that way. For us, the single exception is, was the activity the child engaged in the kind of activity that normally only adults engage in? Driving a truck on the highway, on the expressway. That's an activity that normally only adults engage in. So if the child's engaged in this kind of adult activity, you just can't say adult activity. Golfing's an adult activity, it's a child activity. The issue is whether it's an activity that normally, not always, but normally only adults engage in. What they're really saying is normally only adults engage in it because it calls for adult qualifications to do it reasonably safely. So there the exception is, you're driving a car out on the highway. Normally only adults drive cars on the highway. You've got to be 16, be licensed, there are qualifications. Therefore, if it's a child, a 12-year-old driving a car, we'll apply the ordinary reasonable person test. And then you're back to statutory violation, learn in hand, whatever's appropriate. So you've got to decide in any situation where you've got a child being sued in negligence, you've got to decide, is the kid going to be entitled to the child care standard or is the kid going to be held to the adult standard? The exception, again, in some jurisdictions is inherently dangerous activity. In other jurisdictions, it's an activity that normally only adults engage in. Usually it'll turn out the same way, but in a lot of situations it will not. Hunting, for example. Hunting with a shotgun is an inherently dangerous activity. Some jurisdictions say 12-year-old, 11-year-old goes out with a shotgun, they're going to have to use the care that an ordinary reasonable person would use. Other jurisdictions say, wait a minute, we don't use inherently dangerous. We use normally only an adult activity. And hunting is the kind of activity that both children and adults engage in. Therefore, we will give the kid the benefit of the child care standard. In having that shotgun, that loaded shotgun, and crawling over the barbed wire fence, that he used the care that a 12-year-old with his experience with guns and his mental abilities would have done. It'll be the child standard. In the other jurisdictions, they'll apply the adult thing to the same activity. So it's sum-sum. Once you've decided whether it's child or adult, you still have to apply it to the facts and see whether they fell below the standard. And that's the child care standard. Back to informed consent for a second. I forgot one other aspect you cannot forget if the way you're proving breach is the failure of informed consent. This doctor did not adequately inform of material risks that the patient didn't know about, and therefore he breached. If you've got breach because of the doctrine of informed consent, watch out for causation. Very often, a doctor will not have informed you of something, but it doesn't matter. You would have consented even if you had been informed. So the doctor was negligent in not telling you, but that negligence didn't cause you the harm. Why? It would have happened anyway. The side effect would have happened anyway. Why? Because if you were told that there's a rare risk of temporary deafness for 3 days, you would have consented anyway to get your legs fixed. So you got a cause and fact issue anytime that you got informed consent. And again, you got a some situation there. Some courts, to avoid this thing of all plaintiffs that you claim, oh, I never would have consented if I'd heard about incontinence. I never would have done it. Because now they're going to claim that because they're trying to get money at trial. The court said we're going to use a reasonable person test. We will decide cause and fact under informed consent by asking ourselves, would a reasonable person have consented anyway? If a reasonable person would have consented anyway, knowing the information, then the negligence has not caused any harm. Other jurisdictions say no. If the plaintiff can prove to the jury that she or he would not have consented had they been informed of the rare risk of incontinence, then you've got both breach and cause and fact. We're going to do it the normal way you decide cause and fact. So watch out for cause and fact. You have to state the rule, the some rules, when you get down to cause and fact, if your breach was informed consent. Okay, let's move on to, then we've done learned hand, we've done professional standard, we've done child standard, we've done informed consent. We get to statutes. Someone violates a statute. Can we use that statute to say they didn't use reasonable care? You can if you meet the law that the courts have adopted for when you can use a statute and when you cannot. Common law courts will use a criminal statute or any other statute that's been violated in deciding negligence and deciding reasonable care if the plaintiff is a member of the class the legislature was intending to protect with that statute, and if the harm suffered by the plaintiff was the kind of harm they were trying to prevent. If you can meet those two requirements, the court will adopt the statute as being the standard of what's reasonable. And the violation of that statute will be the proof of breach. If doing 25 is what's reasonable, you're doing 40, you breached your duty of reasonable care. But you have to first meet those requirements. Are you the kind of person they were trying to protect? Is what happened to you the kind of thing you were trying to protect against? We saw the example of fireworks. You can't sell fireworks here in the district. Someone does that. Your child eats the fireworks, sues for negligence for the pain caused by the fireworks poisoning. Did the district government adopt the statute, the ban on selling fireworks to protect whom? Well, undoubtedly, he's a member of the class intended to be protected. They're trying to protect all kids from fireworks, probably adults too. So plaintiff is a member of the class intended to be protected. But is the harm he suffered here the harm they were trying to prevent with this statute? No, they're trying to prevent burns and explosion harms, inflammatory harms. They didn't pass the statute against selling fireworks to prevent poisoning. They got other statutes for that. It was not the purpose of the fireworks ban. Fire was the purpose of the fireworks ban. So the child could not use the fireworks statute to prove breach. They'd have to use learned hand or whatever other argument the kid had. So when you see a statute or an ordinance or a regulation in a fact pattern, you know you're going to have to deal with, can we use the violation of that as proof of breach? First, state the two requirements. Plaintiff, member of the class intended, harm suffered among the harms they were trying to prevent, intended to prevent. If so, the court will adopt it as the standard of reasonable care. If not, they won't use it. You're back to arguing one of the other methods. Often it'll be arguable whether it's met, and therefore you're going to have to use one of the other methods anyway, because the court might disagree with your conclusion. So if you've got the statute adopted, the next thing you have to know, the court has adopted it, then the violation is breach if it's an unexcused violation. So the rule is, unexcused violation is negligence per se. The jury has no choice. The court will instruct the jury. If you find that this statute was violated, you must find breach. If it's an unexcused violation, Burden of proof and excuse.